Good evening. My name is Amy Petway, and I'm an attorney with the Legal Aid Society of Palm Beach County, Incorporated. I am working in the fair housing and consumer law units. And on behalf of our firm, I'd like to thank you for joining us for this discussion on how to get your landlord to make repairs during COVID-19. I would like to start off by just thanking you for being here and wishing you and your family health and safety during this difficult strain of the virus. And we're hoping to focus you in on really important issues that you need to report to your landlord rather than smaller issues that can wait until a time where it's safer to go in and out of your homes. So let's get started. What must landlords do by law? Florida statute requires under section 83.51 that landlords comply with applicable building, housing, and health codes. Or if there are none, then under section 1B, and that's the third bullet point down, the landlord must maintain the roofs, windows, doors, floors, steps, porches, exterior walls, foundations, and all other structural components in good repair. And they need to be capable of resisting normal forces and loads and the plumbing in reasonable working condition. Note also that at the beginning of your tenancy, the landlord is required to make sure that good screens are installed and that they work in reasonably good condition. But after that, each year, the landlord must make sure that those screens are not damaged and that they're in good repair until the end of the tenancy. The landlord is not required to maintain a mobile home. So if you are living in a mobile home structure and you are the owner of it, you should not look to the landlord to make any repairs under the statute. The only time that that is true is if you have something in writing like a lease or some other kind of agreement that directs the landlord to make repairs to the mobile home. And finally, if you are living in a structure other than a single family dwelling or a duplex, for instance, if you have a unit in a high rise or a condominium, then the landlord is responsible for extermination of rats, mice, roaches, ants, wood destroying organisms, and bed bugs. When you have to leave your home in order for the landlord to do this extermination, the landlord would not be responsible for any damages to your unit. Instead, the rent would be abated or decreased to the amount that the unit has the value of at the time that you're gone. Now, I started out earlier by saying that you want to make sure that you report incidents of things that need to be repaired based on how important those incidents are, or how whether or not the unit is going to be habitable, or if there's any dangerous issue that could come up because it's not repaired. And we call those damages uninhabitable, meaning that you can't live there or that you're in danger of being hurt, you or your family members, because the property is damaged and not repaired. And so usually those kinds of instances would be if there is water or leaks, something with the plumbing that could eventually lead to mold or some kind of breathing hazard. It also would include things like inoperable appliances and fixtures. If there's an air conditioner that the landlord is required to fix and it's leaking, or it's not functioning properly, it's not heating properly, something that could lead to some kind of breathing problem, then you definitely want to report those kinds of issues. And of course, extermination of pests. You don't want any pests running around having the ability to hurt you or your children. Those are the kinds of issues that you want to report even during COVID. The rest of it, for instance, if you have some kind of electrical issue, not a serious one, let's say there is a problem with one of your outlets in a kitchen, and you can use a different outlet that works in the kitchen, that's not major. And that's not something that I would recommend you call your landlord to fix, because it's not something significant. And certainly you don't want to run the risk of having a landlord or repair people coming in and out of the unit during the Delta variant. It's very contagious and it's something to be taken very seriously. So on the whole, you want to make sure that the issues you report are things that are dangerous enough to make the unit not livable. Sorry. How do you report those disrepairs? Well, we call it a 7-day letter or a rent withholding letter. This letter is very specific. It is statutory, which means that the statute mandates that certain things be in the letter in order for it to be effective and in order for you to have a defense for an eviction action. It has to be something that's written right down to the letter. We're going to go through each step and then we'll look at a sample letter on the next slide. But what you want to first do is make sure that the demand is put in writing and it has to have the current date. Many callers, many tenants that we represent have made calls to landlords. They leave messages, they leave notes, sticky notes on the door. That's not sufficient. It needs to be in a letter form and it needs to have the current date on it. We'll talk about why that's the case later. You also need to specify what repairs need to be made. Make sure that if there is an issue, let's say with a sink that's leaking, well, which sink is it? Is it in the master bedroom? Is it in the guest bedroom? Is it in the kitchen? Be specific about what the repairs are so that the landlord will not be confused or not have any excuse to direct his attention to that problem. Make sure you provide that the repairs need to be made within 7 days. Notice that I have Florida statute 83.51 in parentheses. That's because that's required. Don't tell the landlord in the letter that they need to fix it in 3 days. It doesn't matter how urgent the issue is. The statute requires at least 7 days, and that's what you want to put in the letter. Obviously, you would want the landlord to move swiftly, as quickly as possible before 7 days, but the statute requires that you put 7 days in. Give him at least 7 days to make reasonable efforts to fix the problem. You also want to provide in the letter that you will withhold the rent unless repairs are made by that 7-day deadline. That's very important. The landlord needs to be on notice that you know your rights as a tenant to withhold your rent. And finally, you want to make sure the letter is sent via certified mail or some other manner that shows that the landlord or his agent has received the letter. And that could be by Federal Express, UPS, again, certified mail, something that you'll get to show that they signed for it and they actually got it. And finally, make sure you keep a copy of the letter for yourself, just for your own records. We may also want it if we intercede on your behalf on an issue of repairs or rent withholding. So here's a sample of what the letter should look like. I've highlighted the portions that are important. The portions that we looked at on this screen are highlighted here. So first, today's date, again, whatever the current date is, it's very important that it's on the letter. You will find that, I guess, in the body of the letter that the landlord will have 7 days from the receipt of the letter. That the current date will measure when he received it, and it will obviously measure the time from when you got notification that the landlord received it, 7 days after that, for reasonable repairs to be made. Notice also that this tenant has sent this letter by certified mail, return receipt. That means she's going to get a green card in the mail to say the landlord has received the letter and there's a signature that someone received it on his behalf. Numbers 1 and 2 in the body of the letter, she has been very specific about where the problem is. There is a leaking pipe in the sink in the master bathroom, and there's mold in the kitchen cabinet. So the landlord knows exactly where to send the proper repair people for these issues. And finally, she said, if every reasonable effort is not made to repair these deficiencies within 7 days, 7 days is the key number. 7 days from receiving this letter, I will exercise my right under Florida statute section 8356 to withhold my rent. Make sure that that language is in the letter. The remedy is not, I will move out. The remedy is not, I will sue you. The remedy is you will withhold your rent within 7 days. And this is 7 days measured from the date of receipt of the letter if the landlord has not made reasonable efforts to make the repairs. Now, what happens if you need repairs, but you have not paid rent? The first thing you need to do is pay your rent or pay as much as possible. Now, we realize that COVID-19 has caused significant restrictions in employment, in the number of hours you work, in the jobs that are available. But whatever money you have, you need to put towards rent. It's important because if the landlord receives your 7-day letter and you have not paid rent, the landlord has every right to file, or I'm sorry, to provide you with a 3-day notice of non-payment, or in cases where you lived in a covered property, which is basically federally subsidized property, they'll give you 30 days notice to vacate. The landlord will be within his right to do that, even though he also is obligated to make the repairs that you've requested. So you need to make sure the money is in, the money has been submitted to the landlord as much as you can, so that if there is a lawsuit for eviction filed, you at least have the ability to tell the court, I don't owe everything, I owe this amount of money, but he still owes me a habitable unit. When can you withhold rent? The statute provides that you can withhold rent when the landlord does not make reasonable efforts to correct. That's under Florida statute section 83.56. Reasonable efforts would be on a case-by-case basis, depending on the kind of repair that you're requesting, depending on how long it takes, whether the landlord has sent someone in and that person can't finish the job within 7 days. It all depends. And if you are unsure about whether or not you can withhold rent, you should definitely contact us. Note also that the statute says that rent shall be reduced, quote, by an amount in proportion to the loss of the rental value caused by the noncompliance. Again, rental value, market value, those are all determined obviously by market forces, and whether or not the amount that you want to reduce your rent by is in proportion to the loss would be a question depending on the circumstances. Many times, if there is a situation that is life-threatening in the home and the landlord has done absolutely nothing at all to fix that problem, then there are many times that we would recommend you're withholding all of your rent. But that is not a hard and fast rule. It would depend on the circumstances. If this is a case that you are facing or you know someone who is, please have them call us and we'll walk you through it. Finally, under no circumstances, even under COVID, can landlords engage in what we call prohibited practices. And those practices are changing the locks, turning off the water, turning off the electricity, turning off the gas, or removing any property from the rental unit. That's not how you solve problems in under the statute when you are renting property out to tenants. What you need to do as a landlord is to follow the the Florida Landlord Tenant Act, which lays out the fact that the landlord has to provide you with notice of non-payment or whatever the non-compliance is. After that, you have an opportunity to cure it. You either pay the rent or make whatever changes you need to make within the time frame. If that doesn't happen, the landlord must go to court and file a lawsuit for eviction and or damages, which is basically money that you owe that you didn't pay for rent. You have an opportunity to answer or to file some kind of pleading in response to that lawsuit. And then the court goes through the process through a hearing or mediation, whatever is necessary according to what the court orders and what you as the parties decide. And then if there is a judgment entered against you, the landlord would get that judgment, and then the writ of possession would be issued, and the sheriff can execute that writ, which means they can go and tell you that you need to move out and start moving your belongings if you haven't already done so. So in a nutshell, there is a process that landlords must abide by the Florida law, and they can't short circuit that. They can't go around it or evade it by changing locks or doing other things that are not permissible. If this happens, notice that the penalty at the very bottom of the screen is that the landlord could be liable for up to 3 months rent. They could also have to reimburse you for any costs or any attorney's fees, excuse me, if you have expended those. But it's critical that you let us know that this happens so that we can be proactive in getting whatever remedies you are afforded. So if this occurs, please let us know. And finally, on this screen, you can call us or you can complete an online intake. The phone number is there, and the link to our website that contains the online intake is also available. Please make sure that you call us or do the online intake as soon as you know of a situation, or if you suspect that you are going to be evicted, or if you believe you have a right to repairs that the landlord has not made by statute and you're not sure about it. We're very happy to help.